For those of you unaware, I appeared alongside Nuala Toman from Disability Action in Northern Ireland and Les Allenby on Wednesday in front of a Department for the Economy committee that did discuss treatment of disabled litigants and persons within the Industrial Tribunal. Now, because it wasn't exactly an environment for me to be able to say everything I needed to say, I've decided that I'm going to just read everything that I had written down. I had expected more questions to be asked of me, and to be fair, I may have been a bit nervous. So what I felt like I needed to say and what I'd written down to say, I wasn't able to. So I thought I'd just read this out. Anyway. In November 2018, I suffered a concussion that, unbeknownst to me, at the time would evolve into a life-changing brain injury. This injury profoundly impacted me and caused multiple disabilities, some which were obvious, some not so much, and some of which I'm still learning to navigate and adapt to today. It has been a catalyst for significant change in my life, and without it, I wouldn't be here before the committee today, nor would I have endured the ordeal of the Industrial Tribunal, and that too became a life-changing injury. Every citizen, every litigant and person, disabled or not, has a fundamental legal right to have their case handled fairly and justly, ensuring they are on an equal footing with a represented respondent. This right is outlined in Schedule 1, Part 1-2 of the Industrial Tribunals and Fair Employment Tribunal Constitution and Rules of Procedure, Regulations Northern Ireland. Similar provisions exist in higher courts, specifically in Order 1 Rule 1A, 1 and 2 of the Court of Judicature, 1980. Both sets of laws are designed to guarantee equality between parties. All courts, as far as practical, are required to ensure that the parties are on an equal footing. When we add disability into the mix, the Disabilities Discrimination Act 1995 comes into play, as does protective case law, like Gallo v Bombardier Aerospace. Yet despite these safeguards, something is very, very wrong in the Industrial Tribunal. In this context, the law provides only the legal basis for the overarching principles I have described without detailing practical mechanisms for implementation. This is left to judicial discretion and bias. This simply isn't good enough. While I wasn't there to contest the placement of the constitutional placement of the Industrial Tribunal, placing an employee justice system within a non-judicial body raises concerns about conflicts of interest, access to justice, judicial impartiality, fairness and procedural integrity. I have hearing transcripts that show economic priorities were favoured over justice-focused oversight, disadvantaging me as someone who needed a thorough assessment, fair treatment and effective accommodations. These were essential, not only to secure my equal participation, but also to ensure the Industrial Tribunal complied with the law and raised me to be on an equal footing, whatever that means, with represented respondents. Unlike the Department of Justice, which is inherently focused on legal standards, the Department for the Economy inherently prioritises economic matters. And when neither department takes responsibility for an employee justice system or its oversight, as is our current position, clear accountability is lost. The Industrial Tribunal cannot be some kind of rogue government body with no oversight, which is why I was there. There's no recourse for employer unlawfulness, no accountability for employer or judicial misconduct, no equal access to justice for disabled litigants in person, and no equal footing. Disabled litigants in person face significant challenges due to their disabilities, with contingency fee arrangements illegal in Northern Ireland and without legal aid for employment matters, or the unicorn that is exceptional case funding. Good luck getting that, or access to essential legal advice. We are forced to self-represent to hold employers accountable. Forced to do it. This burden makes an already difficult situation overwhelming, especially when we are already at our most vulnerable. For disabled litigants in person who already face complex medical challenges, this creates an especially brutal and punishing experience. I had no ground rules hearing, despite my claim being flagged as a disability discrimination claim on my ET1 form. My needs were not assessed until the 7th hearing, and this was only because I forced the issue. I had no knowledge of legal terminology. I had no knowledge of industrial tribunal rules. I had no knowledge of procedures, and I knew nothing about it. I had no idea that I was subject to an implied undertaking, which is now being challenged in defamation proceedings, where I am the defendant. Because of my cognitive disability, I did not understand that I had to request discovery within a certain time period, despite it being in writing for me, and to that extent I never received any discovery from the respondents. In fact, during the substantive hearing, important documents that I was referring to in the bundle that I had requested from the respondents via a subject access request, which I subsequently provided to them via discovery, they were left redacted in the bundle, and the Industrial Tribunal had no problem with the lack of full and fair disclosure in relation to that. In emails I sent to the Industrial Tribunal and the respondents through their legal representatives, and that I spoke of during the 7th hearing, I communicated that I needed a script to ensure my full and effective participation in the substantive hearing. There was word counts involved in this exercise that were not communicated to me by the Industrial Tribunal, and my script was rejected by both the respondents and the IT. I was made to rewrite my script, which was something I had been writing for months. And while reading the judgment after the substantive hearing, I discovered that the respondents had not agreed to our pre-arranged hearing bundle. No one told me. The IT were under a legal and procedural duty to inform me of this as part of their overarching objective, and the legal professionals as part of their roles as officers of the court. My right to a fair hearing under Article 6 of the Human Rights Act was breached due to this failure. Critical evidence that supported my case and demonstrated the duration of my disability, which is a key consideration under the Disability Discrimination Act, was disregarded by the Industrial Tribunal as recorded in the judgment. Do these procedural failures sound fair, just, equal so far? The relevant period of my claim was from 31st of July 2020 to the 14th of October 2020. The Industrial Tribunal, emboldened and unaccountable, cherry-picked from tweets I posted in 2021 to inform their decision about events that occurred during that time frame. At that point, I was fighting back against face mask disability discrimination that I had faced in society that was created by the Northern Ireland Assembly, by Robin Swan, the Department of Health. It was ignored by the Equality Commission, the Northern Ireland Human Rights Commission, and it was perpetuated by figures such as Stephen Nolan, Naomi Long, Alan Stout, and the mental health champion in Northern Ireland, Professor Siobhan O'Neill. The Industrial Tribunal used these tweets as proof of an ideological motivation against face coverings, despite the relevant period for my disability claim being as stated, disregarding evidence that was recorded by the respondent company, which states that I quote, "I previously provided a medical explanation for her unwillingness to wear a face covering." The Industrial Tribunal cited the bundle disagreement as justification. So going back to my script, I found a Law Centre Northern Ireland video a few months ago that showed a litigant using a script, a pen to read from paper in front of her. I was never afforded this adjustment despite having a disability and despite needing a script. The Industrial Tribunal allowed me the use of an aid memoir, and if you don't know what that is, it's a tool that allows for flexibility and delivery when given a presentation. So I still am not capable of the flexibility needed to utilise an aid memoir. I found out during a preliminary hearing to discuss the IT's reconsideration of their judgment that as a lay person who knew nothing of the IT, I mistakenly used the term script. In legal circles, it's known as a speaking note. This was only suggested to me then and offered for use during the reconsideration hearing, not before that. Neither the industrial tribunal or the legal professionals involved made the simple connection between the words to support my effective communication in the substantive hearing. Going forward, you will find weak references being made to the Equal Treatment Benchbook. This is only a superficial acknowledgement of fairness and equality. The Court of Appeal in its 2016 Gallo ruling was scathing of the IT's failure to utilise this resource. I first learned about it during the same case management hearing for the judgment reconsideration, and I wasn't aware of its significance. When I addressed this issue for the judge in an email after that hearing, that as the Gallo ruling in 2016 made clear, she had a duty to consult the Equal Treatment Benchbook to ensure fairness. She didn't acknowledge this legal obligation. Instead, as recorded in the reconsideration judgment, she shifted to a narrative that was crafted to demean and embarrass me in the public record, rather than address my legitimate point about the equal treatment. The Equal Treatment Benchbook may not be binding, but the Industrial Tribunal is bound by its own rules and by the overriding objective to treat litigants fairly and justly. The IT's consistent failure to provide procedural transparency, adequate support and enforce equitable standards highlights its role only as a mechanism of employer protection. By structurally disadvantaging employees, especially disabled litigants, the Industrial Tribunal obstructs the very principles of fairness and justice it purports to uphold. Without systemic reform, the Industrial Tribunal will continue to function as a means of employer protection, leaving employees without recourse to justice or accountability and exposing them to further discrimination, inequality, and neglecting the necessary oversight you and your department, the Department for the Economy, forfeit the responsibility to ensure justice, judicial impartiality, fairness and procedural rigour. These failures are amplified by the absence of basic ground rules hearings that would identify assessments for reasonable adjustments to enable a litigant's effective participation. Without mechanisms in place to genuinely support and protect disabled litigants, the fundamental promises of an equal footing, fairness and justice are an ideology. The Department for the Economy Draft Audit of Inequalities and Action Plan 2022 to 2027 states that part of the Department's responsibility is to provide regulatory services. Yet my case, alongside many others, demonstrates that under the Department's jurisdiction, the IT is continually failing to comply with or uphold the law. How is Minister Murphy acknowledging that while the names may change, the law and my rights remain consistent, committed to upholding the rule of law and addressing unlawful practices within the Industrial Tribunal? 8 years ago, the Court of Appeal's 2016 Gallo ruling had already exposed the Industrial Tribunal's contemptuous treatment of litigants in person, and despite this, these issues have persisted, further confirmed in 2020 through a report by former Judge Paul Buggy, titled Personal Litigants in the Employment Tribunals Improving the System. This report reinforced what was already known, that litigants in person are systematically disadvantaged within the tribunal system under the Department for the Economy. The Ministerial Code and the Civil Service Code of Ethics in Northern Ireland are clear. All ministers and departments must comply with the law and uphold justice. These codes, backed by the Northern Ireland Act 1998, require that government bodies operate legally and ethically in exercising all functions. The DFE's responsibilities go beyond merely providing the tribunal. They include ensuring compliance with the law and upholding justice. Providing a service inherently includes ensuring that the service meets the regulatory, procedural and statutory requirements expected of a public body. The DFE, the ministers that come and go, the civil servants who oil the cogs are not exempt from ensuring that these services operate under legal and ethical standards. The time for avoiding responsibility is over. In calling for accountability and procedural fairness, I can't ignore the role of judicial oversight, particularly that of the Lady Chief Justice, whose duty it is to ensure that all courts and tribunals under her purview maintain fundamental standards of justice. The Industrial Tribunal's structural deficiencies and procedural shortcomings are long-standing and well documented. These issues fall squarely within the Lady Chief Justice's responsibility to oversee and rectify. Yet, in the face of clear evidence that these failings obstruct access to justice, no intervention or guidance has been issued by the Lady Chief Justice to remedy these structural injustices. Engagement and action from the Lady Chief Justice must be sought if the promise of equal footing and access to justice is to be more than an ideology. The desperate need for judicial guidance on implementing fairness, justice, equality is clear. Without it, we are left with a system where judicial discretion and bias perpetuates inequality rather than mitigates it, and where already vulnerable people are abused just because they can be. Every person, regardless of ability or representation, deserves an equal opportunity to access justice. If the Lady Chief Justice will not safeguard this principle, who will? The Department for the Economy haven't been. The Department of Justice aren't. The Industrial Tribunal certainly isn't. Every single one of you must ensure that the Tribunal operates in compliance with relevant law, including equality law. The failure of all to act highlights the urgent need for a structured, independent inquiry into the Industrial Tribunal's practices, an inquiry that holds not only the Department for the Economy, but also the involved judiciary accountable. To truly uphold these legal rights, a structured framework is essential, one that translates these principles into actionable, enforceable procedures and support systems that guarantee equal participation for disabled individuals. As we have seen, without such a specific framework, existing laws do not ensure procedural equality, accessibility, or the specific accommodations necessary for disabled litigants in person to navigate tribunal proceedings effectively and fairly. I reviewed a Law Centre Northern Ireland document which purports to be a guide to accessing the Industrial Tribunal. Unfortunately, they called it a guide to the Employment Tribunal, which for many people, not only disabled people, will cause confusion. This guide is linked on the Industrial Tribunal Fair Employment Tribunal website under Process, and the document, if accessed online, links to Ulster University guidance. And while the provision of this information is very welcome, it is obvious from the outset that there was no input from disabled people. I do consider myself to be somewhat more cognitively able than what I was. However, I didn't recognise that this document links to further information. The link is in similar colour to headings and subheadings, and the language is inaccessible and impractical, and the best part, the practical help, only covers 4 pages. The guide lists a few sources of free legal advice but does not reflect reality, and the actual access to these services is restricted and limited. It suggests that witnesses may attend the Industrial Tribunal by simply confirming numbers, which is misleading to readers. My own request for witnesses was denied. There's references to witness statements but no mention of procedural rules, such as standard word limits or potential reasons for rejection. This is practical information that isn't included in the Ulster University guidance either. The guide also omits mentioning the right to a reconsideration hearing. It jumps straight to the Court of Appeal. Why? Other basic and fundamental legal rights are neglected. It lacks a summary of fundamental industrial tribunal rules, such as implied undertakings, which is not legal advice, basic guidance and rules. It's fundamental knowledge that will empower disabled litigants in person to navigate the tribunal process with a basic understanding of their rights and procedural expectations. These gaps only leave disabled litigants in person unprepared with expectations that will never be fulfilled. Any framework must support disabled litigants in person. It must raise them to be on this equal footing, this other unicorn, acknowledging that while adjustments may vary on a case-by-case basis, fundamental rights apply universally and must be identified clearly for all individuals. physical simplified guide, perhaps modelled after the Law Centre NI's version, would be welcome. It must be provided to every disabled litigant in person, as holding documents solely online is insufficient. Not all disabled litigants in person have consistent internet access or the digital literacy required to navigate online resources effectively, which particularly disadvantages disabled individuals who may face additional cognitive or sensory challenges. The physical guide allows for easy reference, highlighting and note-taking, fostering better engagement and retention of critical information. Additionally, relying exclusively on online documents can lead to information overload, as disabled litigants in person may struggle, and I still have this issue, to filter relevant details amidst other content. By providing a language, accessible and concise, practical and physical guide, the Tribunal ensures that all disabled litigants in person, regardless of digital access or technical skills, start with the same foundational information, promoting fairness and consistency in support. This approach is not only more practical, but also more equitable, allowing all disabled litigants in person to navigate the tribunal process confidently and effectively. The guide should inform them of their fundamental rights, simplify the industrial tribunal rules, and outline claimant and respondent expectations, explicitly outline the basic accommodations and procedural adjustments they may be entitled to because of their disability. Outline basic examples of adjustments that they may be able to request to ensure effective participation. Ensuring that each disabled litigant in person is equipped with a clear understanding of what they can expect and request as a matter of right is not only a statutory obligation, but an ethical one. Should the Industrial Tribunal remain under the Department, to secure legal integrity of any framework, I request that the Department of Justice conduct independent monitoring to ensure compliance. Such oversight would provide a reliable check on the system, guaranteeing that the framework is consistently applied and that disabled litigants in person's rights are fully realised in practice. Establishing a framework and guide backed by independent oversight is critical. It will provide a clear and actionable basis for upholding procedural equality, ensuring that every citizen, particularly those with disabilities, is genuinely placed on an equal footing within the industrial tribunal system. Have I anything else to say? I don't think so. In the context of Wednesday, no time. I think I was asked one question about about representation and why I wasn't represented. I'm sure going forward, you may have questions, so please feel free to ask. But the truth is out there. The truth is online. And hopefully I'll be able to make sure it's recognised and that changes will be made.